I have spent decades listening to people make extraordinary claims inside a courtroom. Some tried to intimidate witnesses. Others tried to impress the jury. But one woman looked directly at me, folded her arms, and confidently declared, "My husband's a lawyer. He'll tell you this case is ridiculous." She expected those words to end the argument before it had even begun. Instead, they led to one of the most unforgettable moments I have ever witnessed. Before that hearing ended, I picked up the courtroom phone and called the one person she never expected me to speak with. What happened after he answered still stays with me. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now, let me take you back to where this case truly began. My name is Judge Judith Harper. If years on the bench have taught me one lesson above all others, it is this. People often borrow someone else's reputation when they don't trust the strength of their own argument. A courtroom, however, doesn't operate on borrowed authority. It operates on evidence. The case involved a dispute between a local parent-teacher association and one of its former volunteer coordinators. The plaintiff was the Maple Grove Elementary PTA. Representing the organization was its president, Rachel Collins, a school counselor who had volunteered countless hours to raise money for student programs. The defendant was Karen Whitmore, an energetic parent who had once served as the PTA's fundraising chair before resigning after a series of heated disagreements with other board members. The lawsuit centered on nearly $12,000 collected during a charity carnival. The PTA alleged that Karen had opened an unauthorized bank account using the organization's name, deposited fundraiser proceeds into that account, and failed to transfer the remaining balance after leaving her position. Karen denied every allegation. She insisted the money had been spent on legitimate event expenses. She claimed the PTA leadership was retaliating against her because she had challenged how the organization was managed. As she testified, she answered every question with remarkable confidence, perhaps too much confidence. Then came the sentence that changed the entire atmosphere inside my courtroom. She looked toward Rachel Collins, smiled slightly, and said, "My husband's a lawyer. He already told me none of this can hold up in court." The spectators whispered. Some jurors looked toward me. Others looked at Karen. I remained silent. Experience has taught me never to react too quickly. Emotion clouds judgment. Patience exposes truth. Karen continued speaking as though the case had already been decided. She repeatedly referred to conversations with her husband. She suggested the PTA officers simply didn't understand the law. She implied that everyone opposing her had been misled. Meanwhile, Rachel Collins never interrupted. She simply organized several financial records into neat folders. That caught my attention immediately. People carrying the strongest evidence often feel no need to speak over anyone. They simply wait. Karen then looked directly toward the jury and said something I will never forget. "If my husband were sitting here, he'd tell every one of you this lawsuit is a waste of time." The courtroom became perfectly still. The defense table had grown louder. The plaintiff's table had grown quieter. In my experience, that usually means the most important evidence has not yet been revealed. Rachel's attorney calmly stood. He requested permission to introduce the PTA's financial records along with minutes from multiple board meetings. I granted the request. As the first documents were handed to the clerk, I noticed something unusual tucked inside the evidence file, a page containing a telephone number. Next to it was a handwritten note identifying it as Karen Whitmore's emergency contact. The name beside that number made me pause. It was her husband, and before the trial was over, that single phone number would transform the entire case in a way no one inside the courtroom expected. The second day of trial began with an entirely different atmosphere. Word had spread through the courthouse that the PTA dispute was becoming far more complicated than anyone had expected. Cases involving school organizations are rarely just about money. They're about trust, trust volunteers, teachers, trust board members. Communities trust that donations collected for children will reach the children. When that trust is questioned, emotions naturally follow. Karen Whitmore entered the courtroom wearing the same confident expression she had displayed from the very beginning. She greeted a few spectators with a smile before taking her seat. Rachel Collins quietly organized several binders containing financial statements, fundraising reports, and bank records. Neither woman spoke to the other. Years on the bench have taught me that silence between opposing parties often says far more than angry words ever could. The plaintiff's attorney requested permission to continue presenting evidence. I granted the request. The first exhibit appeared on the courtroom screen. It was the official PTA checking account statement covering the months surrounding the annual spring carnival. The attorney explained how the organization normally handled donations. Every fundraiser followed the same procedure. Cash was counted by 2 volunteers. Deposits were made within 24 hours. Monthly reports were reviewed during board meetings. Everything was documented. Everything required multiple signatures. Then the attorney displayed another statement. This one belonged to a different bank. A bank where the PTA had never officially maintained an account. The account name immediately drew everyone's attention. Maple Grove PTA Activities Fund. The attorney looked toward Karen. Whitmore, do you recognize this account? Karen nodded. Yes. Who opened it? I did. The admission came quickly. Without hesitation, the courtroom remained silent. The attorney asked another question. Did the PTA board authorize you to open this account? Karen folded her arms. They didn't need to. Several jurors immediately looked up from their notes. That answer had changed the direction of the case. Years of judicial experience have taught me that authority inside volunteer organizations matters just as much as authority inside businesses. Good intentions alone do not create legal authority. Karen attempted to explain. She claimed the existing PTA account processed deposits too slowly. She insisted she created the new account only to make fundraising more efficient. According to her, every dollar had ultimately benefited the students. That explanation sounded reasonable, at least on the surface. But courtroom experience has also taught me something equally important. When someone creates an account using another organization's name, documentation becomes critical. The attorney then introduced the account opening paperwork. Every signature belonged to Karen. No second officer, no board approval, no meeting authorization, no written vote, nothing. Only Karen's signature. Rachel Collins remained completely composed. She never interrupted. She simply watched as the evidence appeared one page at a time. Then the attorney displayed copies of PTA meeting minutes from the same period. Every monthly meeting had been recorded, attendance budgets, fundraising totals, committee reports. Yet there was no mention whatsoever of the new bank account. Not once. Karen shifted slightly in her chair. It was the first visible sign of discomfort I had seen from her. Then she smiled and said something that immediately caught my attention. It doesn't matter what those papers say. She glanced toward the spectators before adding, "My husband reviews legal documents every day. He told me I didn't do anything wrong." The courtroom grew noticeably quieter. Again, she wasn't relying on records. She was relying on someone else's profession. I looked down at the emergency contact form resting in the evidence file. The telephone number beside her husband's name remained in plain view. And at that very moment, I began considering a step I almost never take during a trial, because before this hearing ended, I intended to find out whether her husband actually believed the words she had just placed in his mouth. The third day of trial began with a tension that everyone in the courtroom could feel. It wasn't caused by raised voices. It wasn't caused by dramatic objections. It came from one simple question lingering in everyone's mind. Had Karen Whitmore been telling the truth about what her husband had supposedly said? Years on the bench have taught me that people sometimes invoke doctors, accountants, engineers, or lawyers as if mentioning a profession automatically strengthens their argument. It doesn't. Credentials are not evidence. Facts are. Karen took the witness stand once again. She appeared just as confident as before, though I noticed one important difference. She no longer looked directly at the jury when speaking about the missing funds. Instead, she frequently glanced toward her attorney before answering. That was new. Rachel Collins remained exactly as she had throughout the trial, calm, organized, positive. Her composure never changed. The plaintiff's attorney resumed his cross-examination. "Mrs. Whitmore," he began, "you've mentioned your husband several times." "Yes, you've testified that he's a lawyer." "That's correct." "And according to your testimony, he advised you that opening the separate PTA account was perfectly legal." Karen answered immediately. "Exactly." The attorney nodded politely. "Did your husband prepare any written opinion?" "No." "Any email?" "No." "Any memorandum?" "No." "Did he review the PTA bylaws?" "I don't know." The courtroom became very quiet. The attorney continued. "So your testimony is based entirely on conversations at home?" "Yes." Again, she sounded certain. But certainty without documentation is a fragile thing. Years of judging have taught me that memories of private conversations become remarkably flexible once litigation begins. The attorney introduced another exhibit, the official PTA bylaws. One section appeared enlarged on the courtroom screen. It clearly required that all association bank accounts be approved by a majority vote of the executive board. 2 authorized officers were required on every account, no exceptions. Karen admitted she was familiar with the bylaws. She admitted she had served on the executive board for nearly 3 years. She admitted attending the meetings where those financial procedures had been discussed. Yet she maintained that none of it mattered because, according to her, her husband had assured her everything was lawful. I leaned back slightly. There are moments in every judge's career when patience becomes more valuable than interruption. This was one of those moments. Karen had now anchored a significant part of her defense to someone who was not in the courtroom, someone whose words could neither be verified nor challenged, unless I glanced once more at the emergency contact form. The phone number remained there, clear, complete. The courtroom clerk noticed me reviewing it. She knew that look. Over the years, she had learned that I sometimes became very quiet immediately before making an unexpected decision. Karen continued speaking. "My husband handles legal issues all the time." She smiled. "He'd tell you exactly what I've been saying." I folded my hands on the bench. Then I looked directly at her. "Miss Whitmore," she stopped speaking. "If your husband were available right now." I paused just long enough for the entire courtroom to focus. "Would you object to this court asking him that question directly?" The smile disappeared from her face. For the first time since the trial began, she didn't answer immediately, and that hesitation told me more than any speech she had given during the previous 3 days. The silence after my question seemed to stretch across the entire courtroom. No one shifted in their seat. No one whispered. Every eye was fixed on Karen Whitmore. Years on the bench have taught me that hesitation is not proof of dishonesty, but it often signals that a person is carefully weighing the consequences of the next answer. Karen finally cleared her throat. I suppose not. It was a very different tone from the confidence she had displayed throughout the trial. Just minutes earlier, she had repeatedly assured everyone that her husband would support every decision she had made. Now, for the first time, uncertainty had entered her voice. I nodded. Very well. I looked toward the courtroom clerk. The emergency contact information in the case file includes a telephone number for Miss Whitmore's husband. Please place the call. The courtroom became absolutely still. Karen immediately leaned toward her attorney. The two exchanged hurried whispers. Her attorney stood. Your Honor, I object. I looked at him calmly. On what basis? He hesitated. I believe any conversation could be taken out of context. A fair concern, I replied, which is precisely why the court will ask only whether he wishes to confirm or deny the statements that have repeatedly been attributed to him during sworn testimony. The objection was overruled. The clerk dialed the number. The speakerphone sat on the bench. One ring, two rings, three. Then a man's voice answered. Hello? The clerk identified the court and asked whether she was speaking with Michael Whitmore. Yes, I introduced myself. Mr. Whitmore, this is Judge Judith Harper. Your wife has repeatedly testified under oath that you advised her the actions at issue in this case were legally proper. I have only a few questions, and you are free to decline if you choose. There was a brief pause. Then he replied, I'll answer. The courtroom remained frozen. I asked my first question. Are you an attorney? Another pause. Then came the answer no one expected. I graduated from law school many years ago, Your Honor, but I have never practiced law. Several jurors immediately looked at Karen. She lowered her eyes. I continued. Did you advise your wife that opening a separate PTA bank account without board approval complied with the organization's bylaws? His response came quickly. No, Your Honor. The courtroom seemed to stop breathing. I actually told her I couldn't answer that because I had never reviewed the PTA's governing documents. I glanced toward Karen. The confidence she had carried into the courtroom had completely disappeared. Michael continued before I asked another question. I specifically remember telling her that if the bylaws required board approval, she should follow whatever the bylaws said. The silence that followed was unlike anything I had heard during the trial. Years on the bench have taught me that dramatic moments rarely come from shouting. They come from simple truths spoken without emotion. I thanked Mr. Whitmore for his time. The call ended. No one spoke. Karen's attorney slowly sat down. He did not ask for clarification. He did not request a recess. He understood what had just happened. Karen had built a significant portion of her defense around conversations she claimed supported her actions. Now, the very person she had relied upon had publicly contradicted that testimony, but the trial was still not over, because one final witness and one final financial record would determine whether Karen's actions had merely violated PTA procedures or whether the missing money had followed a path no one in the courtroom had yet discovered. The final day of the trial arrived with a feeling I have experienced only a handful of times in my career. Not suspense, clarity. The evidence had been presented, the witnesses had testified, the documents had been examined from every possible angle. Now the responsibility belonged to the jury. Karen Whitmore sat quietly beside her attorney. The confidence that had marked her testimony during the first day was gone. She no longer referred to her husband's legal background. She no longer claimed he had approved everything she had done. That chapter of the case had closed the moment he answered the telephone. Years on the bench have taught me that truth has an unusual quality. It doesn't need to be repeated once it has been clearly established. The plaintiff's attorney delivered a measured closing argument. He reminded the jury that the PTA had never claimed Karen intended to harm children or destroy the organization. Their claim was much simpler. She accepted a position of trust. She ignored the financial procedures she had agreed to follow. She opened an unauthorized account in the PTA's name. She controlled donated funds without board approval. And when questions were raised, she repeatedly blamed everyone except herself. Karen's attorney argued that she had been an overworked volunteer trying to solve administrative problems. He insisted there had been no malicious intent. He urged the jury to focus on the successful fundraiser rather than procedural mistakes. It was a thoughtful argument. Good intentions sometimes explain poor decisions, but they do not erase them, especially when money entrusted to a community organization is involved. The jury retired to deliberate. The courtroom grew quiet. Rachel Collins clasped her hands together and stared at the floor. Daniel Brooks remained composed, though I could see the exhaustion in his face. Karen sat motionless. Nearly 4 hours later, the clerk informed me that the jury had reached a verdict. Everyone returned to the courtroom. The foreperson stood. The verdict form was handed to the clerk and read aloud. The jury found in favor of the Maple Grove Elementary PTA. They concluded that Karen had violated the organization's governing procedures by opening an unauthorized account, exercising exclusive control over donated funds, and failing to account properly for all transactions before leaving her position. The court ordered Karen to return the remaining funds identified during the accounting process and reimburse the PTA for its documented financial losses. Karen closed her eyes. She said nothing. Rachel Collins quietly wiped away tears of relief. There was no celebration, only the visible release of months of uncertainty. Before dismissing the parties, I offered one final observation. Volunteer organizations survive because people trust one another. Parents donate because they believe every dollar will be handled responsibly. Teachers volunteer because they believe others will honor the same commitment. That trust is fragile. Once broken, it takes years to rebuild. Then I reflected on the moment that had changed the trial forever. Karen had repeatedly insisted, "My husband's a lawyer." She believed those words would strengthen her position. Instead, they became the turning point. When I asked that simple question and the courtroom phone connected us to the one person she had relied upon, the truth emerged without drama, anger, or accusation. He didn't embarrass her. He simply answered honestly. That honesty mattered more than every confident claim made during the trial. As I gathered the final exhibits, I looked once more at the financial records, the board minutes, and the phone log documenting that unexpected call. Together, they reminded me of a lesson every judge eventually learns. Authority cannot replace evidence. Confidence cannot replace documentation. And borrowed credibility disappears the moment the person behind it speaks for themselves. That case has remained with me for one reason. Justice was not decided by the loudest voice in the courtroom. It was decided by the quiet consistency of the facts. And in every courtroom where I have served, the facts have always had the final word.